Good afternoon and welcome to our webinar series, Estate Planning for Digital Assets. I wanted to mention a couple of upcoming chapter events. We've got our Member Appreciation and Holiday Social on December 14th from 5 to 7:30, and our quarterly meeting, Annual Federal Tax Update and an Economic Outlook from the Atlanta Federal Reserve on January 19th from 7:30 to 10 a.m. Check out our website for details and register now. Today we are joined by Elizabeth Faist, who practices tax law, primarily serving clients in the areas of trust, estates, charitable planning, income tax planning, and tax controversy for Djuric Spratt. Please submit your questions via the Q&A feature within the Zoom controls at the bottom of your screen. And with that, I will turn it over to Elizabeth to begin.
Good afternoon. Thank you so much for having me. I am primarily an estate planner, but formerly a tax attorney. And so I will talk a little bit about tax today, but the primary focus is going to be estate planning for digital assets. So I will go over what I mean by digital assets. I'll talk a little bit about how they're taxed and how they could be insured. And then the primary bulk of the discussion will be about fiduciary access to digital assets. So I'll talk about how we access our digital assets, but then how we can allow fiduciaries, including executors, powers of attorney, agents under powers of attorney, trustees, custodians, and guardians to access those digital assets. And the ways in which the law has evolved. I'll try not to spend too much time reading statutes to you, but tell you about some tools for some commonly used custodians of digital assets, including Google, Facebook, and Apple. And then I will talk about the default rules. If our clients don't use the tools that are available to them, what are the options that we're left with? So first, digital assets. Digital assets is an electronic record in which an individual has a right or interest. So the best examples of a digital assets are files containing text, spreadsheets, graphics, or presentation decks. Even my PowerPoint is a digital asset. All your image files like photographs, artwork, logos, video files like YouTube videos you might create, or even those little clips you take of children and grandchildren. Social media and blog postings like Instagram, Facebook, TikTok, etc. Another big category is electronic communication. So those are the texts and emails that you send between loved ones, between colleagues, etc. And then the other types are the financial assets: virtual currency, another virtual property, cryptocurrency, and non-fungible tokens. So I'm going to touch on what cryptocurrency is, non-fungible tokens. Luckily, I don't talk as much to my clients about those types of assets, but they are certainly part of the consideration. So distinguishing digital assets from other assets. So there's some distinctions here. An electronic bank account statement is a digital asset. So when I log into my Bank of America account, for example, that statement is a digital asset, but the underlying bank account and the assets within it are not digital assets. So emails saved in your email account, those are digital assets, but not the emails printed on a piece of paper. So if you printed out all of your emails and put them in a file, that paper is not a digital asset. So an image file of work or art or photo is a digital asset, but the copyright in the work of art or photo is not. Also, work in the form of a digital file minted into a non-fungible token is a digital asset. So that's what you hear, NFT. And an NFT token representing a smart contract or providing evidence of ownership of real estate is a digital asset. But of course, the contract or real estate itself is not. Also, the postings and followers of a social media influencer are digital assets, but the rights to the name, image, and likeness are not. So some of the characteristics of digital assets, these are not tangible property, nothing that you can touch. They are also, they could be titled the same way that you hold other types of assets, but it's sometimes more difficult to determine titling than it would be for other assets. Some of the issues that have been raised that have not been settled are digital assets community property? Are they subject to equitable division? For instance, all the photos, family photos in a Google account, for example, are those subject to division? Or do you have a certain privacy right if all of the images are on your own personal form? We also don't have a lot of settled law on whether digital assets can be owned and bought and sold by minors. Another big question is valuing digital assets. For most of us, myself included, most of my digital assets, while I have lots of them, photos, videos, etc., they're probably of low value to others, but they may have high value for myself and my family. So then when we consider the digital asset planning for fiduciaries, a lot of time there's not a monetary value for these types of assets, but some of our clients will hold digital assets that have significant monetary value. You may have followed some of the auctions of NFTs that sort of hit a peak in 2022 and 2021 that were sold through similar auction type, the way that you would sell art. So some of the large art dealers like that Sotheby's and Christie's have digital art and NFT regular sales and have some specialty market for those types of assets, but not the typical client who is really concerned mostly with social media postings, family photographs, emails, etc. So digital currency, of course, those are the types of financial digital assets, also called digital money, electronic currency. There's three different types to distinguish. So there's virtual currency, which is used as a medium of exchange in a specific virtual environment. I think Roblox in the Roblox online game platform is the best example. There's cryptocurrency, that's your Bitcoin. And then there's central bank digital currency, which is a type of central bank money like reserves balance or cash in the form of a digital asset. And so virtual currency, the first type, is never legal tender. Cryptocurrency is legal tender in only 2 countries, and CBDC, the central bank digital currency, is legal tender. So cryptocurrency has been incredibly volatile. I'm sure if you've had conversations with your clients, there was a lot of interest, and then maybe less so in the recent past. And so the issues that we see as estate planners a lot of times is if they have it, if a client has the cryptocurrency, we need to know where it's kept, because of course it has to have its own separate wallet, its own separate way of accessing it. And oftentimes, in an effort to keep these sorts of assets private, we find restrictions on our ability to access the actual wallet if something happens to the owner. So to be held in an investment account, cryptocurrency must be held by a qualified custodian. So some banks are qualified custodians, but some banks have determined they will not hold cryptocurrency. There are some trust companies that are willing to hold to become qualified custodians or have expressed interest. For instance, in 2020, a Wyoming chartered public trust company obtained a no action letter from the Wyoming Division of Banking, permitting it to provide custodial services for digital assets and to consider itself a qualified custodian. But holding cryptocurrency is like holding a briefcase of cash, and fiduciaries are often have to assess the risk of holding such an asset. And of course, cryptocurrency and similar digital assets are not addressed in the Uniform Prudent Investment Act. So going back to non-fungible tokens, again, this is any digital file that can be minted as a non-fungible token. The creator of an NFT promises that the NFT is unique or at least rare, And so, so scarcity and proof of ownership are what give it its value. And again, there's a question of regarding whether a fiduciary could invest in an NFT. So the future regulation of digital assets. On March 2022, President Biden signed an executive order to establish the first ever comprehensive federal digital assets strategy for the United States. This would help position the U.S. to keep playing a leading role in the innovation and governance of the digital assets ecosystem. However, the recent collapse in the values of cryptocurrency has resulted in not a lot of action on this particular issue. And so we haven't seen any comments since that March 22 executive order. However, there have been some developments in the taxation of digital assets. The IRS has provided guidance that they are treated like other assets for tax purposes. Transactions are generally reported in the same way we would, we and our clients would report transactions on our 1040. In 2014, the IRS explained the sale or other exchange of virtual currencies or the use of virtual currencies to pay for goods or services, or holding virtual currencies as an investment generally has tax consequences that could result in tax liability. So now we use digital assets as a term in IRS documents. And so you'll see, and here are some examples about how the digital assets have been addressed on the Form 1040. It's now a part of, at the top of page 1, you'll see that the question has evolved. So for instance, in 2020, you saw that, did you receive, sell, send, exchange, or otherwise acquire any financial interest in any virtual currency? So that was anything from receiving a gift to sending currency to just buying it. So any transaction involving virtual currency, which has now evolved to, for example, in 2022, at any time during 2022, did you receive as a reward, a reward, award, or payment for property or services, or sell, exchange, gift, or otherwise dispose of a digital asset for a financial interest, or a financial interest in a digital asset. So it's a little more restrained in what is being asked, but certainly something that we will need to address, and and accountants will need to ask about when reporting on an annual basis. So here are some additional, so there has been some additional guidance regarding which transactions require checking the yes box. So that's receiving as a payment for property, receiving digital assets as a reward or award, receiving assets as a result of mining, staking, or similar activities, receiving digital assets as a result of a hard fork. That's, I mean, very simplistically, just like a stock, similar to a stock split. Disposed of digital assets in exchange for property or services, or disposed of digital assets in exchange or trade for another digital asset. So some exemptions from having to check the yes box on the 1040 include holding a digital asset in a wallet or account. So now just having those assets is not something that you have to answer every year. Transferring a digital asset from one wallet or account you own to another wallet. So it's just like changing the custodian of your bank account. Purchasing digital assets using US or other real currency. So no longer needing to report a transaction in which you're just obtaining some virtual currency. So there have been some additional reporting requirements. For instance, brokers were to begin reporting digital asset transactions on Form 1099-B as of January 1st, 2023. So we'll see this as the first year that requires some additional restrictions or additional requirements. However, on December 23rd, 2022, the IRS postponed the reporting requirements until there were some final regulations. So we anticipated that there was going to be a lot more reporting required in this taxable year, and then it was postponed. Similar to, we saw the executive order in March of 2022, and by the end of the year, there was much less interest in regulating digital assets. So insuring digital assets, we have not seen a lot of options for insuring digital assets. For example, a typical homeowner's insurance policy is typically wouldn't explicitly excludes these types of assets. And so we haven't found good options for insuring digital currency or the loss of other, digital assets that have high sentimental value. So now turning to after we know what digital assets are, what is our role in planning for those digital assets and making sure that those digital assets can be passed on to our beneficiaries or managed on our behalf in the event of death or incapacity? So that's where our roles can come in, is to raise these issues with our clients, even if they don't have virtual currency, but because all of us have these digital assets that may have sentimental value. So the traditional estate planning concept is that if you name a fiduciary, like an executor is the best example, is that they will step into the shoes of the decedent, meaning that once the person dies, the executor sort of takes over their financial life, and they are able to access, receive their mail and look inside all the boxes that they have in the back of their closet. So there's this ability to take over and know that person's private information that they might not otherwise have known if they were alive. The issue that we have seen that is raised with digital assets is that most digital assets are held by a custodian, a third party that had originally entered into a contract with the original user. So for instance, I originally set up a Gmail account many years ago, and I entered into a contract with Google, for example, and it's the terms of service agreement, which you probably often see maybe on an annual basis when we say, yes, I will renew my terms of service agreement and I will accept the contract that we've entered into. So the issue that was raised with accessing these digital assets was the fact that these custodians felt that they were honoring the privacy of their users because that's what their terms of service agreement said, that they were just going to hold these digital assets for the benefit of the user. And the traditional fiduciary concepts of stepping into the shoes of the user, they would not honor that typical fiduciary relationship that we as estate planners had become so accustomed to. So the issues that we saw as the law developed was that there was a constant conflict between estate planners and the fiduciaries that were named trying to get access to digital assets held by a custodian who was just relying upon the terms of service agreement. So the tech service providers had little use for deceased or incapacitated customers. So often what would happen in the past is that the accounts would just be terminated and the digital assets would either be deleted or forever inaccessible to the fiduciaries that the original user had named in their will, their revocable trust, or even in their power of attorney. So when the Uniform Law Commission, that is just a group of lawyers who are interested in developing new laws, they came to the tech service providers and their lawyers and said, how can we come up with a better solution for accessing these digital assets without jeopardizing your view of the user's privacy? And so, and just to digress, an example is Microsoft's terms of service agreement that I referenced protects the privacy of the user and provided that an inactive account will be closed and the content deleted. So it's as if when a deceased user dies, their account will be closed and there's no more reading through their emails or finding videos or photographs that might have been attached to emails. So that is a very traditional view of how tech service providers would deal with accounts like a Microsoft account. So now, you know, there is a uniform law that has been uniformly adopted among many states. And so, and a lot of these slides are just on sort of the history of the evolution of the views. But I think it's important just to jump ahead because I think we're all on the same page now, the lawyers and the tech industry, in that they have developed this Uniform Fiduciary Access to Digital Assets Act, which was then revised. And so the catchy acronym now is RUFADA. So it's RUFADAA. And that has been adopted in Georgia in July of 2018. And I'm going to go through the provisions so you can see how the tech industry and the lawyers compromised and what is available to our clients under this uniform law that has been adopted in 46 states, DC, and the U.S. Virgin Islands. And we're surrounded by states who have also adopted it. So it's something that you can talk to your clients about, and it's pretty ubiquitous, other than a few outliers. So to go to the content of that law and see where our compromise found us is that we have a similar definition of digital assets that's meant to be consistent across all states. So an electronic record in which an individual has a right or interest. So that's our common baseline. And the term does not include an underlying asset or liability unless the asset or liability is itself an electronic record. So that's the carve out. And the definition of that's also important is electronic communication. So that is your traditional text, emails, correspondence, etc. That's exchanged between you and another person. And so to go to electronic communications, there was a further distinction of those electronic communications that are important. So those two distinctions are the catalog of the electronic communication. So that's the information that identifies each person with which a user has had an electronic communication, the time and the date of the communication, and the electronic address of the person. So that really, if I open my Gmail account, which is my best example of this is the to, from, date. This is the log. This is the log of all your emails. The content of the electronic communication is the information concerning the substance or meaning of the communication. So that is really the body of my email. So a catalog can be very helpful sometimes to our clients, but sometimes the content is really what's important. So for instance, a catalog might be able to show you that if you searched a catalog, you could see Bank of America or you could see Truist Bank. These would all be in a catalog, which would help an executor be able to say, okay, I know that she has an account at this institution and she might have a retirement account at Vanguard. Just that electronic communication could be helpful enough to the executor, but the content of electronic communication may be where the sentimental value is. If there's a record of electronic communication between me and my son or me and my mother. So those two distinctions, catalog and content, will come back up again. Some other common defined terms, user, I've used that before. That's the person who set up the initial account. So I am the user of my Gmail account. Custodian, that's the person that stores the digital asset. And so that in this instance would be Google as the custodian. The terms of our agreement between me as the user and Google as the custodian, that's the terms of service agreement. Something we all have said yes to a million times and have unlikely to have read the content. Account means the arrangement under the terms of service. So I have user is Elizabeth, custodian is Google, terms of service agreement is an agreement between me and Google, and the account is the arrangement under the terms of service. So that is my Elizabeth Faist at Gmail account. So RUFADA, this uniform law applies to a fiduciary acting under a will. So that would be an executor or personal representative, depending on the state, or a power of attorney. So those are traditional fiduciary arrangements. So the personal representative acting for a decedent, a guardian conservatorship for an adult or for a minor, and a trustee under a revocable trust or an irrevocable trust. So the law applies to a custodian if the user resides in the state or resided in the state at the time of the user's death. So typically, if depending on where the decedent died, the user's death, if I died in Georgia, I was a resident of Georgia, then any action under RUFADA that my fiduciaries were trying to institute to gain access would all be within the state of Georgia. So the big concept that the tech industry and the lawyers they compromised on is they said, we're not going to give you what you lawyers want, which is just access to everything. We would like to give each of these tech companies who are custodians the ability to give a little bit of to create what they called an online tool that could allow the user to direct, how that particular account might be used after death. And I'm going to show you the three options that are most common or available to us, the three online tools. So that would be the Facebook tool, the Google tool, and the Apple tool. And so these online tools were meant to encourage the users to use that online tool that's available to them from the custodian instead of relying upon this sort of automatic access to digital assets. I will get to the default rule if the user does not use the online tool that's available to them. But this online tool concept is probably the best. It's the most useful, practical thing that we can bring up to our clients. So I know there's a lot of things to discuss with a client, but I and my colleagues have added to our question list, like, do you use any of these? Providers? And if so, have you considered their available online tools? So I think that will be the most practical part of our discussion is going over these online tools. So the user's direction using the online tool would override any contrary provision in a term of service agreement. It was also hoped that it would, by allowing these online tools would encourage other custodians to provide those, to create those online tools. Unfortunately, many of the custodians have either declined to do so or explicitly declined to do so by just terminating accounts, or they have just relied upon the default rules, which I will cover near the end. So I'll start with Yahoo and AOL because those two have been combined. They do not. Yahoo does not provide an online tool. Instead, it relies on the old same terms of service agreement. So for Yahoo, it just terminates at the user's death. Of course, there's always the instance where spouse has the password for the user, and so if an account remains active, it is unlikely that Yahoo will terminate the account, but they're never going to allow a spouse who is appointed as an executor to access the account. They can only request to close the account, sort of preventing any future spam or preventing future fraud using that particular account. For AOL, which is under the same terms and service agreement as Yahoo, if the account is active, then the fiduciary may access the account. But if the AOL determines that the account is inactive, then it will be closed in the same way that a Yahoo account would be terminated. So a little bit of a distinction without a difference, but the idea is that if the account is active, whether it be by legal or illegal means, then it would continue to be used. But if there's inactivity, then the fiduciary is unable to access that particular account. Microsoft also does not provide an online tool, but seems to prevent to permit someone with the user's credentials to gain access to the user's Microsoft services and accounts. So there's some additional guidance that Microsoft provides that if Microsoft must be formally served with a court order, so that does require court action, and it must be served on Microsoft's registered agent in the state where the requesting party is residing, or where the venue is, perhaps if the decedent's account was in that state. And they will not accept faxes or emails, so it must be a court order. I don't have any examples, or I've not had any experience with attempting to gain access to a Microsoft account, but that's a cautionary tale for accessing Outlook accounts, etc. And I'll talk at the end about employer accounts. So I will wait till the end for that one. Okay, a few major custodians, as I mentioned, do have useful online tools. And so that is the Facebook, Google, and Apple. And of course, you know, they all have their limitations. But I am going to go through each of those in a little more detail, because those are the ones that we call to our clients' attention. So Facebook has the legacy account service, legacy contact service. It's pretty simple, relatively speaking, but it does only provide limited powers. So for example, the legacy contact is someone that would be chosen by the person who is using the account. And it's someone you choose to look after your main profile if it's memorialized after you passed away. If you add a legacy contact, that person will be able to make decisions about your main profile once it's memorialized. So they can write a pinned post for your profile to announce a memorial, for example, update your profile picture and your cover photo, request the removal of your account, and download a copy of what you shared on Facebook. You cannot access, can't log into the account that I would use, for instance, if I have a Facebook account. The legacy contact could not read your messages and cannot remove or add new friends. So the next tool is the Google's Inactive Account Manager, which is relatively simple. So it is accessible from the Data and Privacy tab on the main Google account options. It provides access if the user's account is inactive for a period of time. Now, the minimum period of time for inactivity to be triggered is 3 months, which of course, if for most of us who check email on a daily basis, it would be something horrible must have happened if I haven't checked my email for 3 days, let alone, you know, for 3 months, something awful has happened. But, you know, I think that is something that they could change in the future, because that's a pretty extensive, a pretty lengthy period of time as the minimum amount that's available. And so, of course, Google, once the inactivity is detected, then the inactive account manager would jump in, so that the unauthorized activity, any unauthorized activity will be detected as activity and would postpone when Google considers the account to be inactive. So of course, our clients ask us, well, if I share my password with my spouse, isn't that just easier? And the answer is yes. The practical answer is, if someone has access to your account using a password, of course, that is unauthorized activity under the terms of service agreement, but practically speaking is much easier to access the digital assets. But when there is someone who has not shared their password with their loved ones or their beneficiaries, but has used the inactive account manager, then there's going to be a wait and see period where to see whether the inactive account manager will kick in. So you're going to see some of the examples of how it's triggered. So you can tell us how long you would like to wait before we do so. So that's that minimum is 3 months of inactivity. And then you can choose the option to say delete if you want your account to be deleted. So after your account becomes inactive, should we delete it and all of its content? If not, then you can, if you've decided that you want your account to be accessible to certain people, what's nice about the Google feature is that you can go in for each aspect of a Google product and say who should be given to access to that particular service. So for instance, I could give Google Drive to my sister, and same for my Gmail, but perhaps to my partner, I give the same access for photos and videos and email. So there's lots of options for providing access to multiple people and allowing them different access to different accounts. And that includes Google Drive, Google Photos, any YouTube account. And so it's worth reminding your clients to see, especially if they're a Google user and they use lots of different Google products, that it might be that they want certain people to have access to certain types of their Google accounts or Google products. And you'll see, and I will get, so I do have a Google account, Gmail account, and so I have used this particular tool, and every few months I get a reminder of reminding me what I selected. So if I want to change that, it's at least Google reminds me that I made these selections. Something we often remind clients who are divorcing is that these tools will override your estate planning documents. And the estate planning default is that if you divorce and then you pass away, and you don't update your will, your ex-spouse is considered deceased. We don't have the same rules here for these types of accounts. So something to consider when someone is going through a divorce and updating these sorts of private selections that they might not otherwise have thought to update. Okay, so then the last online tool is the Apple Legacy Contact, which is part of the iOS 15 update. Allows a user to designate a legacy contact who have access to the user's digital assets stored on Apple's iCloud service and on Apple devices. So this this tool only applies when a user has died, so would not apply to, say, if someone whose power of attorney was stepping in because of incapacitation. So the issue with the Apple product is that the legacy contact must have been provided with an access key that is generated at the time that the legacy contact is designated. And so if the access key is provided to another Apple user, then it can be saved in like a digital wallet or on your iPhone. But if your access key is provided to someone who does not use Apple products or doesn't have an Apple account, then they have to have a printed, they need to print the access key that's generated and have it available for the future. So that's a bit of a snag in that particular tool. The other issue with the access key is that it's generated automatically and notifies the person who has been named as a legacy contact, versus the Google tool, which allows you to update the inactive account manager and never notifies the person that you've named in that particular tool. So they all have some quirks that make them both useful and not useful depending on the circumstances. So the legacy contact with the Apple tool requests access to the user's digital assets with this access key, and then the legacy contact is provided a new Apple ID, and they will have full access to the user's iCloud account, including digital assets, and can restore an iCloud backup on an Apple device. They will not have access to licensed media in-app purchases, like they won't have access to your Kindle library, payment information, or saved passwords to third-party services. So access is limited to 3 years from the time the legacy contact's request is approved. So there's a long time period, but sometimes the issue is going to be, do you have your the access key? And so I haven't had to use this particular tool yet either, but it's something that I have used and set up for my own Apple products, and have decided to name another Apple user just for the ease of keeping track of the access key. So those are the three most common online tools. We're staying on top of whether people are using them, but for now, if the tool, even if the tool is used by a client, we still have to consider what we're going to do with the rest of the user's digital assets that may not be on one of those three most largest custodians, the ones who provided the online tools. So we have to think about the rest of the digital assets, and we have to think about what would happen if they either didn't use the online tool or didn't use it in the way that it was intended. So then the default under our RUFADA statute is direction in the document. So it says that if a user has not used an online tool to give direction, or if the custodian has not provided an online tool, the user may allow or prohibit in a will, trust, power of attorney, or other record disclosure to a fiduciary of some or all of the user's digital assets, including the content of electronic communications sent or received by the user. So the user's direction in a document overrides any contrary provision in a term of service agreement that does not require the user to act affirmatively and distinctly from the user's assent to the terms of service agreement. So these that means that we had to start thinking about how we were going to draft in our documents. And I'm going to show you some options of how we have dealt with drafting in our estate planning documents. But finally, RUFADA provided that if the user has not provided direction using an online tool or in a document, the terms of service agreement controls. So that's when we're always left with the terms of service agreement, which is not generally is not favorable to accessing accessed by a fiduciary. So if the document names a fiduciary, then the default rule addresses both the content of electronic communications, the catalog, and other digital assets. So just a reminder, the content of electronic communications is the body of the email. The catalog is the to, from, subject, etc. The log, and then other digital assets, of course, are the photos, videos that are not electronic communications. So a fiduciary may not access the content of electronic communications without the consent of the user. So for instance, if I name a fiduciary and I say, the fiduciary should dispose of my digital assets, but if I do not affirmatively say that they can have access to the content of my electronic communications, then the default is that I would receive a catalog of electronic communications and I would receive the digital assets owned by the user. So that's the big distinction, is that there must be some affirmative reference to the content of electronic communication. So a fiduciary may have access to the catalog of electronic communications and digital assets if necessary as part of the fiduciary duties. So our best example is the catalog being a helpful information about whether a decedent, if I don't know anything about their financial affairs, if I could look at a catalog and search bank or search Truist or search retirement asset, and I would at least know where to go to ask the right questions. Because of course, what we used to advise an executor to do is, monitor the mail. But of course, we all do most of our banking and financial transactions, and information gathering is now done online. So the catalog can be sufficient for an executor to then be able to get the information that they need to locate underlying assets. But the executor may also need to access an online document storage service, or may want to be able to give out or distribute in equal shares, for example, the photos and the videos that will have that sentimental value. So just to look at a couple of the statute, a custodian's disclosure of the catalog of electronic communication. So there is a lower threshold for obtaining a catalog of electronic communications. So it requires a written request, it requires certified copies of death certificates or letters testamentary or letters of administration. And then the custodian may ask for additional evidence, and many do. And some and the default is that the custodian may require a court order, but we have seen that custodians will require a court order. So that is usually the last hurdle, is if we can get, the death certificate and the letters testamentary, then we can usually move forward, but it's getting the court order to get the custodian to agree to provide that catalog. So then the consent or court order for disclosure by custodian to personal representative. So this is the statute regarding if a deceased user consented to the disclosure of the content of electronic communications, again, the body of the emails, then the custodian shall disclose the content. And this requires a written request, same certified copy of the death certificate, a certified copy of the letters testamentary, and unless the user provided direction using an online tool, then there has to be evidence, a copy of the user's will, trust, power of attorney, etc., that evidences that consent to the disclosure of those electronic communications. And again, then there's the custodian, what they may ask for, which is sort of evidence linking the account to the user, and of course a court order. So we are seeing that at least evidence from other states and here in Georgia that the custodians are requiring a court order. So while it says may, they are that the history has been that they are requesting these court orders. There's a reference here to ACTEC, so that is the American College of Trust and Estates Council. It's sort of the most highly regarded of my profession. It's a group of trust and estate counsel lawyers who work on issues in our professions, and their digital assets committee is working on a model for a petition and court order for the disclosure of digital assets, so that there can be a more standardized process. Because the intention was always, if you checked the box of RUFADA, then the custodians should acquiesce. But the experience has been that the custodians are not making it easy on the fiduciaries when it comes to accessing both catalogs and content. So even if the custodian agrees to disclose the content, the custodian has a lot of discretion on how the digital assets will be disclosed. So either grant the fiduciary or designated recipient full access to the user's account, meaning that it's as if you are using the decedent's account. You could add partial access to the user's account sufficient to do the tasks that are permitted under the court order, or they could provide a copy of the record either in in the form of a USB drive, or maybe there's you download just copies from the custodian. So, and in addition, the custodian can charge an administrative fee for the disclosure. I haven't had a fee quantified yet, but that's always something that we want to mention to our clients. So Google explicitly requires a court order in every instance of fiduciary assets, at least in our experience. And so even if the inactive account manager, dealt with certain products, but there are other digital assets that the user failed to designate someone using that tool, then it's possible that the fiduciary could access those products. But the issue is that Google has a pretty regimented process that they have explicit language regarding their court order, and it is more cumbersome than we thought it would be, given that Google has this relatively sophisticated tool. We've seen that a majority of the requests to Google fail. And we've seen that even if they don't fail, that they just provide these copies of digital assets, and it doesn't have, it's not the full access that someone might want in order to get the assets that they're trying to view or to use. So there are some additional instructions for Apple users that have continued even after using the legacy contact. Apple has encouraged its users to plan for their digital assets stored on iCloud and Apple devices, providing detailed instructions for obtaining a court order. So again, the custodians are tending to tell you exactly how they want the court to order in order to get the information you want. So you're often relying on what the custodian wants to hear in order to get the fiduciary the access that you're hoping for. And so then we get to, well, how do we as planners, the estate planners, make sure that we're addressing these assets in the way that our clients want us to? And so, because so many states have adopted this RUFADA, that the language has tried to be more standardized, especially coming from ACTEC. And so, I'm going to show you some examples of how we deal with digital assets. So, for example, we'll have a definition of digital assets, and then we will say that the executor is authorized to have access to all of my digital assets. And then we explicitly say, including the content of electronic communications sent or received by me, and to provide any custodian with a written request for disclosure, including sort of a list of the information that you would find in the statute. And the idea is to link it as closely to RUFADA so that we can rely on that law in order for the fiduciary to gain as much access as we would like. We try to call this provision to our clients' attention. Obviously, when drafting a new will, there are lots to think about. It's making sure all the names are correct. It's making sure, the financial assets are going where they should. So digital assets are often an afterthought. So the goal here is to have a provision that we think effectuates the intent of our clients. So in our form, we provide the disposition of tangible personal property as a defined term before the disposition of the residuary estate, meaning that our wills start with, this is what happens to my stuff. And we acknowledge that digital assets are specifically treated like the tangible personal property. So a very typical provision would say first to my spouse, and if my spouse does not survive you, then divided among my lineal descendants per stirpes, for example. So to my 2 children, and then if one predeceases me, then it would go to the grandchildren. But we've seen that lumping in the digital assets means that each child gets a portion of photographs and each videos, and so that's something that executors need to grapple with if other estate planners deal with digital assets similarly. So certain property is specifically not treated as tangible personal property, which means they're disposed of as part of the residuary estate and could end up in a marital trust or a credit shelter trust, for example. And so the exclusions that we have are cryptocurrency, digital wallets, and electronic money, so that those financial digital assets end up as part of a residuary estate, for example, as opposed to photographs, videos, texts, emails, which are more tangible personal property, which is unlikely to be distributed in a trust format, for example. So another place where we deal with electronic communications is in the power of attorney, and that is a document that our clients sign to name an agent to make financial decisions. In Georgia, the default is that is a durable power of attorney, meaning that it survives the future incapacity of the principal, meaning that if I sign the power of attorney, it's effective upon signing. And then if I later become incapacitated, there's no trigger to the use of the power of attorney. It was always accessible for the agent to use on the moment of signing. So something just to think about, that if you decide as a principal to sign a power of attorney, one of the options in the statutory form in Georgia is under what have sometimes been called hot powers. These are the grants of specific authority. So in the Georgia form power of attorney, there is general authority, and that is the more traditional banking or financial powers, like access banking, transact real estate, file an assurance claim, file taxes. And then you have these hot powers, or the specific authority, which is a lot of these powers are the ability to change the principal's estate plan, including amending, revoking an inter vivos trust, making gifts, changing rights of survivorship, etc. But within that list is also access the content of electronic communications. And that's an explicit reference to digital assets, in that we explain to our clients that if they access the content of electronic communications, not only would an agent be able to access, digital assets themselves and a catalog of electronic communications, but they could read the body of your emails, which, could be helpful, but it could also, you are alive while this agent is acting. And so accessing content of electronic communications means that your agent conceivably would have access to read the content of all of your emails, including ones that you may be still sending during your life. So that's one that's probably the main conversation we have about around digital assets, is when our clients are signing these statutory form powers of attorney, calling this particular provision to their attention, and sort of giving them examples of when it could be helpful and when it could feel invasive. So this, in the power of attorney, you're allowed to provide special instructions. So what most of the lawyers here do is, we have the form where you're initialing powers, but then there's a few pages at the back of the power of attorney that includes special instructions. And so that's where we include this provision, for example, that says my agent is authorized to have access to all of my digital assets, and again, including the content of electronic communications sent or received by me. And so that again is the explicit reference to the content of electronic communications, like we do in our will documents. So some practical issues that I want to touch on before I talk through questions. And this is a big one. So RUFADA does not apply to a digital asset of an employer used by an employee in the course of the employer's business. And I have a couple of cautionary tales here. So for example, we had a doctor who used his employer's email service at a local hospital as his primary email address, and he used that. He also had a separate financial life from his spouse, and meaning that his spouse knew he had some accounts here, some accounts there, but was really quite unaware of his financial status. And as were we, as it was a relatively new client for us, and he passed away unexpectedly. The issue that we had was that employee, of course, in his email, he had his own personal financial information, but he also had lots of personal health information about his patients. And so, of course, the local hospital this was before the enactment of RUFADA, but of course, even at that time, the healthcare service company was not going to allow an executor to access that information. And so we had to find other ways of accessing financial information. This is also something that I think you all can remind your clients as well, like we do, is if I see someone, engaging me for estate planning and they're using their work email address, is to remind them that hopefully this is not their only email address, and hopefully this is not where they're storing digital assets or conducting, personal business. Because of course, none of these rules or online tools are going to be available to the user of an account that's provided by an employer. And the last is that minors without the capacity to make a will are limited in their planning for digital assets in most states. In Georgia, though, the age of the ability to provide a will or to make a will is age 14 in Georgia. So, our high school students here can provide direction, for instance, if they are running a YouTube account or an Instagram influencer, for example. So there are maybe more opportunities here in Georgia to do planning for minors if there is some value in their digital assets. And so that's something to keep in mind. And then I included my contact information and of my colleague, Nick Djuric. He is my mentor and also helped to prepare these materials. We have found that this topic has been interesting, and we talk about it a lot, and we were both involved in the enactment of RUFADA, but we don't talk about it as much with our clients, and we probably should, because I think that it will become an issue that we deal with more and more.
Thanks, Elizabeth. Wow, there's so much to consider with our digital footprints and assets as you've described today. Thanks so much. And we do have a question in from Kirsten. She says, most of my clients are in California. Does California and the few other states that haven't adopted RUFADA have their own laws around how these digital assets should be accounted for and in the state plan?
I don't know enough about the ones, California is not one and Louisiana is another. I don't know enough about their laws, but I think we're back in the dark ages before RUFADA, where you're left with what's available under the terms of service agreement. I do think that it's worth those clients in those states considering the online tools, with the hope that if a user uses the online tools, at least the fiduciary would be given some deference if they were named in one of those online tools.
Great. And yes, we got a question in about the slides, and yes, we will be sharing those with all the attendees. And that's all we have for today. So I want to thank you again, Elizabeth, for this very informative presentation and best practices. And thanks to everyone who connected with us today. Look for an event survey, the replay, and the presentation to follow. And I hope everybody has a happy Thanksgiving holiday.
Thanks for having me.
Thanks so much. Bye-bye.